No one lays down the law like Car and Key. This is the Law Report on SAFM.
And a very good evening to you from tonight's Law Report program. Well, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight, it's again time to open the lines for you to ask that legal question that doesn't quite fit into the other topics we discuss here on the Law Report. Now, usually we're joined by Nicolene Skuman-Low, but this evening we're going to be joined by two people, Arinda Trutter and Andre Nokia, and they are junior associates at Skuman Law Inc., attorneys, conveyancers and notaries public, and they practice here in Cape Town. Arinda, welcome back. You haven't been here for a while.
Yes, it's lovely to be back.
And Andre, welcome to you. We had you, my listeners might have heard you chatting the other day on the show, but you haven't joined us for one of our phone-in programs, so welcome to you.
Thanks so much, Corin.
Right, and just a reminder, we're not doing labour law tonight, so no labour law questions, and in general, no property law. But Andre does like to talk about sectional title, so we might have one or two questions on that, but only on sectional title, no other aspects of property law, because when Ishmael comes in to do that, that's when we focus on that. So if you'd like to call us with any questions you might have, it's 0892 10 2010, 0892 10 2010, or you can SMS us on 40938, 40938. But before we get to the calls, we've got just two emails we just need to get through. And the first one says, I would like to know if a medical aid can claim money from me that possibly stems back to 2012 or the first 6 months of 2013. Now, there's quite a long story involved with that, but there's relatively simple answer. We don't even have to go through the whole story, do we, Arinda?
No, I don't think we have to go through the whole story. Obviously, the legal term that she's specifically asking for is prescription. And prescription runs for 3 years unless it is interrupted by either issuing a summons, or if the debtor makes a part payment of the debt or acknowledges that he or she is liable for the debt, which she doesn't mention in her matter has happened, so we can assume that the prescription wasn't interrupted.
Now, the only time when she had any contact with them, she says in December 2016, she got an email demanding payment of an overdue account. She then says, I wrote and told them, since years had passed, I felt I could not be held responsible. Last week, I received another demand saying I was going to be handed over to the debt collector and all expenses would be for my account. So the only correspondence she's had with them is via that email in which she said, no.
Yes.
So she hasn't made.
Perfect.
She didn't say, oh, well, maybe I'll pay you 50 Rand a month. She hasn't made any offers of payment.
She hasn't made any offers. She hasn't paid anything. She hasn't acknowledged anything. So that's perfect. So she can just tell them, no, raise the defense of prescription. Don't bother me again. And if they should then issue summons against her, I would advise her to get an attorney to just raise prescription so that the case can just end there.
So basically, after 3 years, this is a debt she doesn't even believe she owes them in the first place.
Yes.
And now they're trying to claim it, and it's after the 3 years prescription. So all she says is prescription applies. Stop bother. But what normally happens, why she suddenly would have got this call, I would imagine, is whoever thinks they owed the money has handed over their debtor's book
to someone else that's trying to collect it now, and it happens a lot, and not a lot of people know about prescription, so then they get this fright and they pay it when you could have just offered prescription as a defense.
Okay, so there's your
not that
your
we
answer.
say we shouldn't pay any debts,
you need to pay them, but in this case she doesn't. It was quite a tragic case, and it really wasn't. It's not necessary. I'm not even going to go through the story because the start of it is what happened, and the prescription applies. So end of story, basically. Yes. Right. Okay, the second email is, in terms of the agreement of a divorce order, my ex-wife was supposed to have paid 50% of the outstanding bond as at the date of divorce from my pension payout. The order was that she will have occupancy and stay with my minor children as their primary residence. The divorce order was granted on the 3rd of March 2013. So far, I have been calculating the amount of interest and capital she owes from the date of the divorce, seeing that I have been paying for the bond alone. I need to know if the order granted on the 3rd of March 2013 will at any given time expire. I also want to know if there's a 3-year prescription on a court order. I had to continue paying for the bond in the best interest of my minor children, even when I do not stay at the house. Can I claim the capital and interest from the date of the divorce from the proceeds of the sale should we now decide to sell the house? So she was going to pay the outstanding 50% of the outstanding bond from the pension payout. I'm assuming that she received from him. That was his pension payout, basically.
Yes, it's not very clear. He's not clear on whether the pension fund actually paid out to her. He doesn't say that in so many words, which in my mind, pension funds have very strict rules and regulations when it comes to payout. And I know for a fact that if your clause in your settlement agreement is not specifically worded, the pension fund doesn't pay out. So it's hard to advise him without having the settlement agreement in front of you, because now I also don't know, is there a time limit to the payout? Is there a time limit to her paying the 50%? The wording will change the context of the question. However, the Prescription Act says that a court order issued out of any court in South Africa has a prescription time period of 30 years.
So it's fine in that
It's
regard.
not going to prescribe at all. So he will have 30 years from the date of his pension paying out to her to claim that money. But my problem here lies with the fact that he says that the pension is payable on date of divorce, the bond amount, which means to me that it's 50% of the bond amount at date of divorce. And if it's like that in the settlement agreement, he won't be able to claim any interest on that.
Right, so
because it's a fixed amount.
But it's been 4 years now.
Yes. So he will definitely be able to withhold that amount should they sell the property. Normally the settlement would say that the proceeds is divided equally between the parties after settlement of the bond, which means that if they sell the property, he can withhold that bond amount that she needs to pay from her 50% that he needs to pay out to her. But that's going to depend on what the amount is, and I can't really advise on that because I don't know the wording of the actual settlement agreement.
Of the pension fund, basically,
yes,
and what they were paying out.
Yeah.
Because I know that we've had questions about pension fund payouts before, and in some cases it was a case of they couldn't get the money. It had to go into another kind of a pension fund. So I don't know whether that's what happened here or
because
you don't know.
It doesn't say. And obviously if she didn't get the money, she can't pay it over. So it's not very clear what the actual case is here. But it's very unfortunate that he's paying for a bond in a house that he doesn't live in.
So what I think the best thing for him to do at this point is to get a copy of that pension.
Yes, and see if it actually paid out.
And see what it says.
Yeah, because obviously if it paid out, then I would say issue summons, claim that amount from her, get it back as soon as possible. Because the problem is, even though the prescription time period is 50 years, you still need to provide the court with your reasons for why you took so long to bring the case. And the court can then authorize you to proceed on your claim based on the validity of your reasons. So we don't know what happened in the meantime here. Obviously he's acting in the best interest of his children.
Which is admirable, because a lot of people don't do that.
Yeah. But I would definitely say you should rather get it sorted sooner than later, or at least get some advice on it.
Okay, I'm going to come, excuse me, to Andre in a moment to talk about some information on sectional title. But before we get there, we are starting to get lots of questions and emails about when is Wills Week this year. Well, Nicoline very kindly sent me some information last week. Says National Wills Week is from the 11th to the 15th of September this year. So obviously you can't go and do it now. It's only in that week of the 11th to the 15th. But what you can do if you want to in the meantime is send me your name and whereabout in the country you are, because then I'll do what I did last year. Once I get that information, I will send you a list of the attorneys available in your particular area. So if you want to email me your name and where you are in the country, the town you live in, to law@safm.co.za, I will then send you that list of available attorneys when they are released. And it's going to obviously be closer to September, probably around about the beginning of September. They'll release that list of names of attorneys, but you can get your name in the meantime. Right, Andre, you are our sectional title man tonight, so tell me, what do we need to know about sectional title? Always hyperventilate the thought, because it always sounds like it could be a little bit tricky.
It could be tricky. Corin, there's two new legislations in the sectional title law area. The one is the Sectional Title Schemes Management Act, and then also closely with that is the Community Schemes Ombudsman Services Act. Now, both of them, they don't replace the previous Sectional Titles Act that govern the governance and the regulations regarding sectional titles and community schemes, but they do, however, try to focus on making the governance clearer between in community schemes and sectional titles. Lots of times we have unclarity regarding how to resolve disputes in these sorts of sectional title schemes, mostly because people in these areas are it's neighbors. You live closely to the people, so the law realized that there needed to be some sort of act or service that could help people resolve the disputes without undergoing costly and lengthy arbitration or court cases sometimes. So I just want to quickly mention the one I think is it's very new, the Community Schemes Ombuds Services Act. It's a statutory body that was enacted to help regulate and resolve disputes among sectional titles neighbours. It helped govern how to deal with disputes without going to attorneys or going to arbitration when it's not really necessary, when the disputes are small. And this Ombuds Services is very new. So other than like the insurance, pension fund services, Ombuds Services, those are all well established and very effective. And hopefully this one, with time and with the process that's smoothened out and people becoming more confident in the process, we hope this one will as well be very effective in the future.
Now, I know when this first came out, a lot of people were panicking because they were saying there's going to be a cost involved. Now, I know someone who has a sectional title apartment or a flat and got their first account and they go, oh, I don't want to see what this bill... It was like about 5 rand or 10 rand. It was a minimal amount. I mean, it was almost nothing.
Exactly.
It wasn't like this whole sort of 100 or 200 rand or something. It was minimal amount.
No, the maximum monthly addition to the already paid levy is a maximum of 40 rand or 2% above the 500 rand that's already paid. But the maximum is 40 rand, so it's not a large amount. There's also, other than the additional levy, there's also a suggested amount that the body corporate need to reserve in funds for future maintenance.
I think that's a jolly good idea.
It's a very good idea. It's so difficult. The amount of times that people get behind with special levies when there's maintenance. As soon as you move into a sectional title complex, you agree that all owners are together responsible for the maintenance of the complex. So this fund will help with future maintenance. The suggested amount is 25% of the levy payable by the body corporate. So for example, if the body corporate or the sectional title schemes pays 100,000 rand altogether for all levies, they suggest, and this is only a suggested amount, to cover future maintenance, an extra 25%. So instead of 100,000 rand, 125,000 rand should then be paid, which the 25,000 is then kept in a reserve fund.
So that's good. I mean, because we've had some horror stories on the show of people either with special levies or with the block falling apart and there's no money. And this, I think, it almost forces them to take responsibility, which I think is a good thing. It
forces them to take responsibility, and also it will make the fixing of small issues or maintenance issues quite more quicker and expedient. For lots of times you have to go through so many processes to get those funds or collect special levies from people that claim they can't afford to pay it, but overall it's only a couple hundred, maybe 1,000 rand extra sometimes, those special levies on top of the current levies payable. So to take this into consideration, I think it's a very good idea. And
are you saying that 25% now has to be paid by the owners, or is that part of they're taking 25% out of the levy? Where's that 25% coming from?
That 25%, how I understand it, as I said, it's in the Act. It's suggested, or the regulations, it's suggested that it's a 25%. So nowhere is that a fixed amount. So the regulations and the legislation suggest that the body corporate collect an extra 25% of the already collectible levies from all owners together.
So if we're paying 100 rand, for example, we have to pay 125.
Exactly.
Okay, people aren't going to be happy about that. Okay, 'cause every little extra bit these days is very, very important.
It is.
So, but nothing has been cast in stone about the amount, or when this has to happen by, or
not the 25%. The extra amount for the levy for this Ombuds services, that is already enacted.
So if people are getting their levy accounts, that's pretty much it now.
Yeah, but that's the first amount that we talked about, that maximum 40 rand.
Yeah. No, I'm saying this other 25% thing.
Yeah, that would be communicated by the community by the body corporate. So it's not going to be a surprise for most people. And also there are waivers that can be applied for at the community schemes ombud services. So if the person can't afford it, or the body corporate feel that the owners are already stretched with the budgets, there are waiver application forms on the website of the service.
Right, well, you tune to SAFM, South Africa's news and information leader. I'm Karen Key, and this is the Law Report. My guests tonight are attorneys Arinda Trutter and Andre Nokia, and they're from Schoeman Law Inc., attorneys, conveyancers and notaries public, practicing here in Cape Town. If you have any questions, you can call us now on 0892 10 2010 or SMS us on 40938.
Saturday nights are EFC nights on SABC3. Every Saturday from 9 p.m. you can catch all the best action from the Extreme Fighting Championship. This Saturday, we take a look at the career of one of the most hard-hitting athletes in the EFC, Zimbabwe's Elvis the Bulawayo Bomber Moyo. EFC Fight Nights, this Saturday at 9 p.m. on SABC3. Brought to you by SABC Sport.
On June 16, 1976, about 10,000 students took to the streets of Soweto to march against being taught in Afrikaans.
When they did that, that didn't work. Whole classes failed.
If they had listened to us, because we had wanted to negotiate, maybe we would have had an experience of June 16.
When they reached Orlando West, their peaceful protest exploded into a bloody carnage of students at the hands of the police.
The only thing that was available for us to protect ourselves was a dustbin lid and a stone.
Although broken and tortured, those students have since paved the way for today's youth and inspired them to take control of their struggle.
Me, I'd rather scrap the floor and do anything as long as I'm going to get paid at the end of the month and sustain a better living.
This June, SABC News celebrates our youth.
No one lays down the law like Karen Key. This is the Law Report on SAFM.
Right, just a reminder, if you have any questions, 0892 10 2010 or SMS us on 40938. Before we take the calls, let's just go to some of the SMSs here. First one says, I have stage 4 cancer. Is assisted suicide legal? And when will euthanasia be legalized in South Africa?
No, it's not legal at the moment. I know they are working on bills and proposals and things, but it's nowhere near.
Not yet, and we don't know when it's going to happen.
No, we have no idea.
It's quite an ethical question. So the law is one thing, and it's legal as far as I know in some countries in the world, but it's a very much ethical question, which I don't think the South African legislation is ready for yet.
Not yet, so we still have a way to go.
Yeah.
Right, another SMS says, I'd like to know the difference between business law and commercial law. What is the difference between business law and commercial law?
Commercial law is basically the same thing. It's just different terms for the same thing. But business law deals with all the law that surrounds your business, all your internal, external things. And commercial law is exactly the same thing. Commercial is businesses. But where business law mainly will deal with, say, your memorandum of incorporation, your shareholders agreement. Commercial law will then be a dispute that revolves around that, so then it would be court work, then it will be commercial court work.
Okay.
But it's basically the same thing.
All right, okay. Right, let's go to some calls now. If you'd like to call in as well, 0892 10 2010. Mfundo in Johannesburg, good evening.
Hi, good evening, Karen, and to you guys. How are you?
Well, thank you, Mfundo. How can we help you?
I'd like to find out exactly what it means for an individual to actually choose the route of debt administration. What does it actually mean in terms of the law? Is that person allowed to seek out credit at a later stage, and at what stage? Do you seek out the credit after you've completed paying whatever you've been paying, in terms of if you can't actually afford your debt and you go for administration? And is administration the same thing as perhaps bankruptcy? What's the difference between the two?
Andre?
I don't know if you guys can help me with that.
Okay, so hold on, Mfundo. I think Andre's got an answer for you.
Yes, Mfundo, good evening. The debt administration, I think, if I understand you correctly, that also refers to debt review. To answer the last part of your question first, it's not the same thing as bankruptcy or sequestration. This debt review is a voluntary process that a person that realizes that the amount of debt or monthly payments become too much, too much debt at the end of your salary that's left. So what a person then does usually seek the help of a debt counselor. A debt counselor will then look at your overall financial status. They'll sit with you. They go through your all your credit agreements, whether it's vehicle financing, bonds, clothing accounts, etc. They will help you to correspond with your creditors.
On your behalf.
Yes, on your behalf. If you then decide to use the services of the debt counselor, what it's called a payment distribution plan. So they correspond with all your creditors and they figure out what monthly amount you are able to pay. So in effect, it's a bit less that you pay each creditor per month. That doesn't mean you get a discount. It might mean that you pay for a longer time or the interest is a bit more. But the process is that you are then able to pay this. While you are under debt review, you're not allowed to undergo any further credit. So the debt counsel will advise you that, and it will also be on your credit records that you are under debt review. This is then made an order of court, which needs to be rescinded in a couple of years, whether it's 2, 3, 5, depending on your personal circumstances on when you are actually able to pay all your all your responsibilities without any further issues.
So from that, would you advise people to take debt review as an option if maybe they cannot like you just said, afford to pay all the things that they need to be paying for example?
Mfunda, before he answers you, I just want to ask a question of my own. If you're under debt review, does that mean, for example, like you mentioned, car payments and that sort of thing, they can't then take your car back?
No. As soon as the creditor agrees with you, as long as you stick to the payments, and as I said, it's usually a bit less than what you were paying before the debt review.
So they can't repossess anything?
They can't repossess anything. You can, when you go to the debt counsellor, what they sometimes do is they exclude the bond, for example. The bond is the most popular one that they exclude from the whole debt review process. So that
Why?
It's usually because it's the main payment that a person has to make, and it's also a commitment for 20 years. So so the problem is, as soon as you put that bond under your debt review, then you are compelled to finish that debt review for a period of 20 years until that bond is settled. But usually it's for credit agreements such as clothing accounts, where you usually have a 2, 3, 4, 5, 6,000 rand credit that can, if under the payment distribution plan, that can be paid fairly quickly if you stick to the payment distribution plan. So you don't want to be committed, because as I said, this is made an order of court. Once you are then have settled all your responsibilities, this is then an order that needs to be rescinded in the court.
And who does that?
You need to get an attorney. That's I wanted to start by answering your second question with that. You asked, would I recommend it? I'd advise people to think very carefully and read up about debt review before you do it. What I've realized is that not all debt counsellors advise you beforehand that once you are finished with this, you then need to appoint an attorney to do the rescission application for you.
And that costs you?
That costs you, because this is not something that the debt counsellor is able to do. They can obviously pay or refer you to an attorney, but that's magistrates' court's cost that the debt counsellor will not pay themselves. So that's an additional magistrates' court. It's a quick application if the payment distribution plans have been settled accordingly to the plans, but but still it's something that you have to consider, even if it's 4, 5, 6,000 rand to pay an attorney for this application.
That's extra money then.
That's extra money.
Now, you mentioned earlier as well that this goes onto your credit record. How does that just automatically come off once this has been rescinded, or do you have to make application to get your credit record cleared? What happens to that?
What happens then?
Okay, so as soon as it's on your credit record, this stays there until if you finish the program with the debt counselor, they give you a form. I'm not gonna I can't recall the form. It's 17 something, or
but they will give you the form.
It's a specific form that the debt counselor provides you, that shows that you are no longer over indebted and you have settled all your debts with all creditors. And once you provide that form to the credit bureaus, they remove that debt review.
So it goes.
Yes.
The other thing we've also had questions on this program about as well are people who've gone to, in inverted commas, debt collectors who have turned out not to be officially registered, and there's been issues with it. How do you know that you're going to the right sort of people? That's the other thing.
Yes.
Sorry, Mfunda, I'm taking over all your questions here. I'm sorry about that.
I'll listen on the radio.
I'm sorry about that. Okay.
No problem.
Thanks, Mfunda. Thanks.
Okay, cheers.
Bye. Right, what happened? How do you know someone's accredited?
There are organizations that they have to be registered with, and easy Google search will show you. I think that there is a debt counselors
association
or something. If unsure, go to the National Credit Regulator. They will be able to assist you or advise you whether the person is an actual accredited debt counselor, because as you've said, you do get the backstreet people that do take chances. They are usually the ones that are interested in getting the debt counselor's fees, but they not assist the person fully.
Now, when you're paying this, you pay the debt counselor and they then pay your creditors, because we've had questions about people paying who they thought were debt counselors who then were not paying over the money to the creditors, and now they were still sitting in trouble with the creditors, and they were paying over all this money to this supposed debt collector or credit debt counselor.
Yeah, that's one reason to do some homework before just paying anyone, because you correctly mentioned that you pay the debt counselor, which then distributes the amount accordingly between all the creditors. So it's important to do your homework and find out from the relevant authorities if the persons are accredited, and it's usually a good indication if the debt counselor is if they have social presence, then it's usually a bit more respectable, if I can use that.
Yeah.
Rather than the ones you
somebody's
haven't
at least heard of them.
Exactly.
I think there's actually a section on the National Credit Regulator's website where it lists the debt counselors that are registered
I think
under them.
Yeah.
So
you can actually go and have a look at that.
First step to look at that.
Yeah, because I mean, you're in trouble as it is. You really don't want to be taken for a ride by somebody who's just out to scam you.
Before.
Yeah, we've had a couple of calls to that effect on this. It's tragic though. It's so sad because people are in trouble. They're trying to get out of it, and then they're taking advantage of them. It's just very, very sad. Right, we're waiting for our next caller to come on the line. Just a reminder. Always happens, they all suddenly start calling at the end of the show, then we can't get them on. And if you want to ask anybody anything tonight, 0892 10 20 10, and call before we run out of time. Before we take the next caller, we've got an SMS here. It says, my divorce order entitles me to 50% of my ex-wife's pension. She has received it but refuses to pay me my share.
So this is almost like the answer.
It's
to
almost
the
like the last one.
had.
This is a different listener. Yes.
So in that case, then if the court order says that she has to pay it and she did receive it, then he can issue a summons and he can claim that money from her.
Because it is legally his.
Because it's legally his, yes. Definitely, in terms of the court order.
And if he has to get an attorney, I always like to ask these complicated questions. If he's got to get an attorney to get his money back, can he do that and make her pay for that?
I'm
just asking.
Yes, if he issues a summons, this is a question we actually get regularly where people come and ask, well, he must pay for everything. But it doesn't always normally work like that, because the court has the decision at the end of the day to say that you have a cost order against you or not.
And the sad thing is that cost doesn't mean the whole cost.
Yes, cost definitely doesn't mean the whole cost. So if he issues a summons and she then defends it, then he can ask that she pay the cost of it. But the magistrate's court fees that you can claim back from the defendant in this case is a bit more than a third of your legal fees.
Sure.
So it's quite a little that you get back, so don't rely on getting that cost back. But obviously if she doesn't defend and he just gets the judgment against her, then that's all his own costs.
Right. Okay, I hope that helps.
Yes.
Okay, right. Lawrence in Durban, good evening.
Good evening to you, sir.
Hi.
I'd just like to know if life rights owners have to pay the Ombudsman's fee.
Lawrence, if I can just ask you to switch your radio off, we can hear we echoing from the background there.
Okay, so.
Okay, right.
Hi, Lawrence. So just quickly go into that life rights portion. It's in a retirement village, if I'm correct.
Yes, we stay at a retirement village, and we have to pay. It's a life rights retirement village, and the owners have to pay the Ombudsman's fee. Is that correct or not?
That's correct. If this is a sectional title scheme or community scheme, then that
It's not sectional title.
Is it a? I suppose it's formed as some sort of community scheme. This retirement village.
Have you seen anything on your account though, Lawrence? Because it will actually reflect on your levy account.
It does reflect on our levy account.
And what are they charging you?
Sorry?
What are they charging you?
Well, it's different rates for different units.
Yeah, that would be right.
That's right, yeah. As I've mentioned, every unit gets billed in a separate amount. That amount is the small amount that's maximum 40 Rand.
Correct, sir. That is correct.
But this amount, if it has to be paid. To answer your question in short, in terms of the legislation that was enacted in October of last year, this amount is a compulsory amount that needs to be paid by every owner in a homeowners association or community scheme or sectional title scheme in terms of this legislation. But as I've mentioned, this is there's forms on the relevant website that one person or the community as a whole can apply for a waiver. There needs to it's a form that needs to be filled out, setting out the financial circumstances, and this is usually when either the association or the respective owners can't afford to pay that extra part of the levy, then this is when you fill in this waiver form.
Is it sort of like a means test type thing?
Exactly, yes.
Right.
Okay, so Lawrence, you do have something. You do have somewhere to go if you'd like to take that up.
No, it's fine. We are clear on that, sir.
Great. Thanks so much. Thanks, Lawrence. Bye-bye.
Thank you. Bye.
Right. Jonathan in Cape Town, good evening. Jonathan?
Warren, how are you?
Hi, very well, thanks, and you?
Very well, thank you. I just want to correct a few things that you spoke about debt counselling
yes, please.
earlier.
Thank you.
Yes. When you put in your bond and you've only got your bond left, you can take a person out from under debt counselling if it's only the bond left. He doesn't have to stay when it's just the bond.
Oh, so you can put the bond in and reduce your payments on the bond while you're in debt counselling, but when you've finished paying everything else, you can take it out.
That's it. You can take it out.
Oh.
And most of the companies has got their own lawyers these days as well, the bigger companies, where they will pay for it in any case because it's not worth it just to have the one account in debt counselling.
Okay, well, I didn't know that. Did you know you could take the bond out? I didn't know you could take stuff out, but you hadn't finished paying it. That's good to know, though.
I think
Andre's looking a bit concerned here.
Yeah, no, I think he's correct. Thanks, Jonathan. I think will this have to be done by court order?
Yes, obviously, it's a court order. You've got 90 days basically to get your court order through.
Okay.
That it has to go through the court. But when you can prove that a client is no longer over-indebted, you can take him out. And it's a 17.7 that you have to launch.
Okay.
You got to 17, right? You knew it was 17 something.
17 something.
Yeah.
Okay.
Yeah, so that's basically the only thing. And if a client wants to come out, like I said, most debt counsellors has got lawyers these days, and they don't charge for it anymore. So yeah.
Oh, that's good news, John. Are you a debt counsellor, Jonathan?
Yes, we are debt counsellors.
Well, thank you for
the CASA is the everybody gets regulated by them.
Okay.
And if you want to see if a debt counsellor is legal, just go check on the NCR. It will see NCR DC and the DC number of the debt counsellor.
That's great to know, because we've had some really horrific calls on the show before, Jonathan, with people that have had really bad experiences. So it's nice to hear that it's not always the case. Well, we know it's not always the case, but how to go about finding out the correct way of doing this.
Yeah, that's definitely. So just go check on the NCR website, and if the debt counsellor is not registered, then don't go with them.
Great. Thank you so much for that. Thanks, Jonathan.
Thank you.
Thanks for calling.
Okay.
Good night. Bye-bye. Right. If you have any questions, 0892 10 20 10, or email. I keep saying email. It's SMSing. I'm way too old for all this technology. The SMS number 40938. We've got a rather long, involved SMS here. I'm not sure if I'm going to understand exactly what's going on here. The listener says, I've completed 1 year as an intern and 1 year community service in 2005 and 2006, respectively. Yet the Health Professions Council have me registered as an independent practitioner in August 2009 instead of 2007. The reason is the technical delay in internship logbook completion, the hospital doctor supervisor's fault apparently, and as a result I can't be promoted to a post 10-year level upgrade called grade 3. As they say, it should now be 2019, dated from August 2009, which is incorrect. The issue is, can I force the HPCSA to back register me to 2007, or force the hospital to give me the upgrade? 2007 to 2017 is 10 years. Please help. Sounds like a bit of a nightmare. So basically they've registered this person in the wrong year. They've actually said in 2009 instead of 2007, which has now stopped the promotion to the next level, because they themselves got the numbers or the years wrong, and it's all because there was a problem with incomplete logbook that had been filled in, and that was the hospital doctor supervisor's fault. So what do you do?
Well, there should be something you can do about that, because it was an error on their side. It was nothing that he or she did wrong. But I'm not sure how to go about it. Because
this is the Health Professions Council.
Yes.
I mean, how do you... And this has obviously been going on for a while, so...
Yeah.
The Health Professions Councils should have a
type of ombud.
A type of ombud, yeah, that will be able to assist with this, or some sort of, I don't want to say union body.
There should be someone that you can write to fix this.
Or phone them. Writing takes way too long. I'm all for instant gratification here, So let's phone them or something now. Yeah, but there should be something that you can refer to.
Yeah, I can't see how it cannot, because it wasn't an error on it side, and now it's affecting the progress.
Absolutely. And I mean, they've got it wrong. I mean, the whole thing started wrong, and then there was a 2-year delay. I mean, an incorrect year put in, and it wasn't their fault. So you need to be able to take that up. I would actually go and just find out, have a look on the internet. There must be something.
There must be some
Health Professions Council ombud, or
somebody
that you can actually refer this to,
that can assist you with this,
because you wouldn't probably be the only person that had a problem.
Exactly, because if there was a backlog, then there should be more.
Yeah, no, I'm sure there would be more. Right, okay, we're going to get some next call up, but before we get there, I just want to go back to the sectional title story now. We had that call about the retirement and the life rights and all of that. It's that all that money, people, whenever you talk about having to pay extra money, people get a bit concerned. I'm still worrying about that 25% sitting there. Okay, so we've got this levy that we have to pay, but that's minimal. As you said, maximum 40 Rand a month that they can charge you.
Yes.
Okay, it's this 25% that's worrying me, because I mean, if it's 25% extra on top of your levy, and say your levy is like 700 Rand or something, you're going to have to pay an extra 25% possibly on top of that. And we're not saying it is 25%. Yeah. That's the maximum you can charge, or they can charge.
That's apparently from the research I've done, that's the recommended amount. I'm not sure how flexible that is, and I think that's up to every body corporate to assess, to figure out what the owners in that scheme can afford, and secondly also what sort of maintenance and repairs are required.
So if they don't need any massive maintenance or repairs and they've already got a good sort of financial cushion sitting there in the bank, do they have to do this? This is what I'm trying to find out. Is it compulsory they've got to increase the levy to cover this, or if they're doing okay anyway, can they just leave it as it is?
I suppose if they are okay as is, I think it's fine to leave it as is. I think the reason for this is to be able to do repairs or maintenance when it's required, and not having to struggle in collecting arrear levies from owners, and just collecting levies as maintenance are done, and then people being unsatisfied or unwilling to pay the extra levies because they weren't notified or informed that the repairs or painting or whatever the,
because that special levy sometimes does come as a bit of a shock, and normally it's quite a lot of money.
Yes, I think the biggest or most popular dispute or complaint in sectional titles is that special levy. I think that's also the biggest reason for people not being able to keep up with the payments. All of a sudden there's a special levy, and that's another cause for dispute, because sometimes the body corporate will say this is a repair or something that needs to be fixed that all the owners are responsible for, where a couple of owners think, but that was caused by one specific owner or something like that. I think it's a large cause for dispute, as is. So this is, as I've mentioned, this is also a very emotional sort of law, because you always dealing with neighbours or friends sometimes.
Well, we were friends before you started. Yeah. Now I've just had a comment put up here on my screen. It says once it reaches the required limit, obviously assuming the amount of money that the body corporate has in its bank account, you only have to top it up to the new level when the levy increases.
Yeah. Okay.
Not quite sure there.
I'm not sure as well. I think it makes sense from a logical perspective.
Yeah. Okay, so if you own a sectional title, I'm sure we'll be getting a letter at some point.
Supposedly so.
Yeah, I'm sure they'll send you a letter to tell you exactly when. You don't know when this is going to be is supposing to come in.
The both
25% thing.
Both legislations have been implemented since October of 2016. So if you own a sectional title or some sort of scheme, if you haven't received a letter, just phone someone on the any trustee on the board or the body corporate, the managing agent. They will be able to advise you and explain what sort of cost you are looking at.
Right, well, you tune to SAFM, South Africa's news and information leader. I'm Karen Key, and this is the Law Report. My guests tonight are attorneys Arinda Trutter and Andre Nokia, and they're from Schoeman Law Inc., attorneys, conveyancers and notaries public practicing here in Cape Town. We've got about 10 minutes left, so you can squeeze in a call if you have, 0892 10 2010.
You have the power to be prepared.
Actually, I am. I realized that life could take a turn for the worst without warning.
It can indeed.
I discovered that Vodacom offers convenient and affordable life cover of up to 10 million rand.
That's right.
In addition to my life cover, I also get salary protection and disability cover. And my cover starts immediately. I also get 20% of my premiums back after 5 claim-free years. It was a simple choice to make.
Right again. Simply SMS live to 31733 and Vodacom will call you. T's and C's apply. Vodacom is an authorized financial services provider. All our products are underwritten by Vodacom Life Assurance Company. Vodacom. Power to you.
Institutions and or individuals are hereby invited to nominate persons to fill vacancies of non-executive members to the Board of South African Broadcasting Corporation Limited. Nominations and inquiries must be addressed to the Portfolio Committee on Communications. Attention Mr. Thembankosi Ngoma, Committee Secretary, via email tngoma@parliament.gov.za, or telephonic inquiries can be made to 083 709 8407. The closing date for nominations is Friday the 30th of June 2017 at 1600 hours. For more information, log on to www.safm.co.za.
No one lays down the law like Karen Key. This is the Law Report on SAFM.
Right, let's go to William in Hammanskraal. William, good evening. William, are you there? No, William is not with us. But he wants to ask about legal aid. So maybe we can just talk a little bit about legal aid, seeing as William's line is gone. But hang on, before we do that, I just want to get through this SMS. Sorry, they keep coming in here. Can an agent just increase your levy without the trustees at the AGM? Then last year, 47% increase. This year, 33%. I'm a pensioner. What can I do? That's a lot. They can't increase your levy by 47% and then the next year by 33%, surely?
That seems unreasonable. It almost seems a bit inflated. But again, I don't know the specific circumstances, but that sort of costs, it's very difficult, especially for a pensioner, to keep up with. You can imagine all of a sudden having to pay 47% extra.
That's a lot. And then the following year, 33. I mean, you're getting close to 100% here. You know.
Yeah, I think I'm definitely not sure if that can be correct. But what I can say is this new legislation, we've talked about the Community Ombudsman Services, but also the Sectional Title Management Act will regulate these sorts of issues more closely. It will keep body corporates and managing agents on their toes a bit more, because the legislation is a bit clearer on how good governance has to happen within these.
Because she says here, can an agent just increase your levy without the trustees at the AGM? I mean, that doesn't sound right either. You need the trustees to be at the AGM. You can't have an AGM surely without the trustees, as far as I'm aware. Yeah. And I'm not sure who the agent is. It would be the managing agent. I mean, they couldn't do that, surely.
It's probably the managing agent, and that doesn't seem right. The AGM, all trustees
have to be there.
They have to have sufficient notice, and before any vote can be made, the quorum has to be there before the vote can be made. That requires a certain percentage of the votable trustees or owners to be there.
Especially on a decision this big.
So I would actually, what could the listener do though? Who could she go? I mean, is there an ombudsman she could go to, the sectional title?
It's, first of all, get all information in order, whether that's statements or invoices.
Or minutes of the meeting or any, that sort of thing.
That sort of thing, contact the trustees on the board, the body corporate, to find out if this is in fact not correct. Then this is a perfect example for where the Ombudsman services can be used. They'll be able to figure out if the correct procedures were followed, and also whether the increases were reasonable, or have been notified, informed, or have the owners or trustees been informed or notified of these increases.
Is there an email address or a website or something for this ombudsman that people can go and have a look at?
Yeah, it's csos.org.za.
Okay, csos.org.za. Right, the listener that actually sent that story in, which sounds absolutely horrendous, I do have your number. I will SMS you tomorrow in case you missed that website address. Just go, I'll SMS you that tomorrow, and you can possibly go and have a look, or ask somebody to have a look for you and get the relevant information off there where you can actually go and do that. Right, we've got William on the line again. William, you need to switch your radio off, William. William, are you there? Okay, great. How can we help you, William?
Yeah, I make retirement pension fund on 2016. I'm waiting. I'm going to legal aid. I'm still waiting.
So what did you do on the in 2015, William? I'm sorry, I missed that. Was it a retirement thing, did you say?
Yeah, it's a retirement Provident Fund.
The Provident Fund?
Yeah, it's a retirement.
And you haven't been paid out since 2015, is that what you're saying?
I'm still waiting.
Okay.
So I go to legal aid.
You were supposed. You said were you supposed to be paid out in 2015 by the Provident Fund?
I don't know.
No, I'm asking, why did you go to legal aid?
Because I'm waiting a long time.
For your Provident Fund money?
Yeah.
Okay. So you've been to legal aid, and when did you go to legal aid, William?
This year on March.
In March this year. I think it possibly will take. It's not that quick at legal aid. It could take a while.
Legal aid takes a while because they have to go through the whole process to vet you, basically to see if you qualify for legal aid assistance. So it can take anything from 3 months up to 6 months to just for them to let you know that a legal aid attorney has been appointed for you. But you can always follow up with them on a weekly basis to keep the pressure on a bit. That's what I would have done.
Yeah, so William, it's just going to take a while. Apparently it takes a good few months. So it's only been a couple of months. You're going to have to probably wait a little bit longer, unfortunately.
Okay.
Sorry about that, William.
Thank you.
Okay, bye-bye. Right, we have another SMS. I got that right this time. It says, what legal action can we take against a lady who is taking rentals on our property without our consent? We're waiting for judgment in the High Court with this lady. We have the title deed in our name and we're paying the levies, not living on the property, yet waiting for the court case to finish. Okay. Right, so they've got the title deeds in their name. They're paying the levies. They're not living on the property. And somebody else is taking the rentals on the property without their consent. So maybe they've got some tenants living in there. I'm not quite sure, and somebody else is collecting the rentals.
That rent.
But if they've got the case in the High Court, there's not really much we can do with that. If it's already in,
that's already the correct process.
Yes.
But how can they? I don't understand the.
I don't understand it completely either.
Some sort of illegal subcontracting.
Yeah,
or something
it sounds
that's
like
happening.
almost like a subletting. Like she's the actual tenant, but she's letting other people stay there.
That's possibly possibly.
Yeah, that's a breach of contract.
Yeah,
if it's in a lease agreement.
Yeah, and I suppose if it's in the High Court already, then you have to get the matter before trial, or get that court order to interdict this person, or whatever relief was sought in the.
And possibly eviction as well.
Yes.
But that's what, she's possibly somebody who's living there, probably subletting it or something, But if the case is in the High Court and they've got legal action pending now, I mean, that's the perfect route way to go, This next one, we've not got too much time, but it says, I've left my country of origin in 2005. I had amassed a huge amount of money in 3 different bank accounts while working in a classified government office, and in the course I got into some political interferences, and what I did was I put caveats to my accounts to avoid them from playing with my money. Took my child to Manchester to study there, and I fled the country 12 years ago. Now I had you saying you direct someone to a legal attorney. Can you help me or your guest? What I want is to remove the caveat and transfer all my money to invest in my businesses here. So obviously they were somewhere else. They put something on, I don't know what the caveat would be that they put on the money. And they're now trying to get that taken off. I don't understand how that works. That you need a financial guru basically to do that. Than legal, That's more of a financial issue.
Question for an accountant.
Yeah. Now we've got a caller called Robert in Secunda called in, wanted to know if we had a call about Health Council registration. Robert, sadly, no, it wasn't about Health Council registration. It was about somebody who was having a problem with the Health Professions Council who had registered them in the wrong year. I'm not sure if that's something that you can help with. Possibly you can just, we can call you back and just get the answer. Basically what happened was the caller had finished all the community service and qualified and everything that they were doing, the internship and everything else. But instead of registering them as 2007, they made it 2009 because there had been logbook delays in filling those in. Apparently the supervisor in the hospital where this person was working had taken too long to fill in the logbook things, and so it pushed their year of registration, I would imagine, 2 years later than it should have been, which is now stopping them from doing the 10-year some promotion that you can get once you've been doing whatever she's doing or he's doing after 10 years. And now this would have to wait another 2 years through no fault of their own. So that's what the problem was. Robert, I'm not sure if you could help. If that is something you can help with, I'm sure my listener would be very grateful to be able to get in touch with you. Let's just have, we've got Robert on the line. Let's have a look. We've got literally a minute and a half to go. Robert, good evening. Are you there?
Hi, Karen. Good evening. How are you?
Hi, very well. Thank you, Robert.
All right. I just wanted to weigh in on that question of that young doctor who called you earlier on.
Yes.
Yes. Basically, what is happening is the Health Professional Council cannot assist him. If the date is wrong, they cannot help because it's based on when they give them the logbook there. it's always assumed that a person must acquire skills. So people acquire skills at different periods. Some actually becomes 1 year, some other becomes a long period. So whatever the supervisor has signed in as a date, the council takes it that that person is competent for that period.
Okay.
So, yeah, so
Robert, thank you. Yeah, we're running up at the end of the program, but thank you so much for the call. Thank you, Robert. Thanks. Bye-bye.
Okay, bye.
Thanks a lot. Bye-bye. Basically, I would still advise my listener to go and just check that out. Well, my thanks once again this evening to Arunda Trutter and Andre Nokia, and they're from Skuman Law Inc., attorneys, conveyancers and notaries public, practicing here in Cape Town, and they've been my guests on tonight's edition of the Law Report program. And Nicolene Skuman Law will be back with us again for another law clinic on Monday, the 10th of July. In next week's program, we'll be talking about customary marriage, finding out about a court case which seeks to end the prescription of sexual offences, understanding more about compliance certificates when you're selling a property, and finding out how employers should be dealing with disability versus medical incapacity. That's the Law Report next Monday, the 19th of June. I'll be back with you again tomorrow evening just after 9 with Health Matters. It's our monthly phone-in. This month we're chatting about men's health with my guest, Professor Shingai Mutomberwa. So join me for that. Stephen Kirk is up now with some nighttime music. Hello, Stephen.